do not have too much time. I would like to just start introducing very briefly the Center for Advanced Studies in the European Union law dedicated to the memory of Paolo Ferroluzzi, that is the hosting institute of this occasion event, and also joined with the Bank of Italy. I'm very happy that we have made this joint agreement in order to enlarge the research activity of this center established at Roma University. And just few words, I am the director of the center, and I'm very pleased that so prominent speakers have accepted to participate to this webinar, and that has a very interesting topic, soft law, especially after the important decision of the Court of Justice 1 year ago. I would like only the floor. Marino Perassi will chair this first session of our meeting webinar, and please, I remember to people connected, the event is recorded. Then people who would not like to be recorded should switch off the camera, and especially should switch off the microphone, because otherwise there could be a problem on noise. Thank you very much to all the people already connected. I guess that the floor, Marino, is yours. Please.
Thank you, Concetta, and thank you everybody for joining this seminar, which is focused on a very important issue for the Banca d'Italia and for other participants in the single supervisory mechanism. Just a few words to highlight some issues that, in my view, are very significant in the architecture of the banking union. As we know, the foundation of the first pillar, the SSM, is a common set of rules, the so-called single rule book. In this set of rules, we have directives, regulations. We have implementing technical standard, regulatory technical standards, and then we have soft law. Well, this third place, this last place of soft law in the ranking of the set of rules is, in my view, misleading, because the hybrid nature of soft law is quite often its strength. And in fact, a number of issues had already arisen in the day-by-day activity of the SSM. First point is the overriding weight of the soft law with respect to regulatory and implementing technical standards. The reason is that, as you know, the single rule book is very detailed, is that thick, you know, but is just dealing with banking supervision, prudential matters. There is no harmonization, there is no full harmonization, for instance, in corporate governance, labor law, fiscal rules all over the euro area. So when we speak about the governance of the banks, of course, we need to adopt some other provision. And the guidelines in soft law is just the best way. And we also know that the European Central Bank, which in principle has no regulatory powers, except in matters left to the discretion of the supervisory authority, quite often adopt soft law just to, how can I say, to clarify which will be the criteria that the ECB will follow in the exercise of its powers. And now we come to the second point. So we have the European Banking Authority, the ECB, and probably other authorities, all issuing soft law. So there is a risk of overlapping of provision. And this risk was raised by the opinion of the Avocat General Bobek, in the opinion released in the Court of Justice case that Concetta mentioned before, the Fédération Bancaire Française case. A risk of overlapping, a risk of multiple sources of soft law. And this is a threat to the legal certainty of the single rulebook. Another point, if you look at the contents of this guideline, the contents are extremely detailed. So at the end of the story, the addressees, the authorities, are in a position of simply opt in or opt out, a sort of take or leave it, when they decide to implement the soft rules coming from the European banking authorities or the ECB and so on. So this is a sort of legification of an instrument which by definition is flexible, the soft law. So a very detailed text of soft law may be detrimental, may impede the activity of the national rule makers, which are expected to implement in a flexible way the general principle coming from the European Union. So now we are approaching the final question, which will be the underlying question in this seminar. Soft law and judicial review. Judicial review is essential in any legal framework. So the question is the current mechanism in the first pillar of the banking union adequate as regard these kind of rules? Is the so-called rule of law sufficiently safeguarded by judiciary review? The sentence of the European Court of Justice in the case just mentioned may play a significant role in clarifying this point. And now we come very quickly to the two main speakers. Just a few words to present them. Filippo Annunziata is, sorry? Okay. Filippo Annunziata is professor at the Bocconi University in Milan, Department of Law. He's teaching financial institution and markets law, international business and digital law, focusing also on fintech. And then we have my good friend of mine, Diego Devaux, General Counsel of the BIS. Before joining the BIS, Diego was Deputy General Counsel of Euroclear Bank in Brussels and the legal advisor in the legal department of National Bank of Belgium in Brussels. At that time, we had the opportunity to work together in the starting phase of the monetary union, you know. So let's start with the first speaker. Filippo, you have the floor.
Thank you very much, Marino. Thanks to Concetta and to the Centro Feroluzzi for inviting me in this seminar that is looking to sort of discuss this very controversial and in part old, in part new issue about soft law, in particular in the context of the banking union. The occasion for revamping this discussion has been raised by the recent Fédération Bancaire Française case and in relation to the EBA guidelines on product oversight and product governance. Now, as a first remark, I have to say that here we are again. This, in my view, is another leading case, another leading major decision coming from the European Court of Justice in the context of EU banking legislation. And this slide is just, the first examples that one can think of, and starting from the Landeskreditbank case to Berlusconi, to Tercas, to Crédit Agricole, to ICREA, just to cite a few with no assumption this list being complete. We really see that jurisprudence is indeed shaping the EU banking legislative framework. It is not merely interpreting or sort of commenting upon the wording of the legislative text, but each of these decisions brings something new and also has implications that go beyond the legislation.
Please mute the phone, please.
Yeah, so okay, here I am again. Said all of these cases have also the capacity of impacting apparently consolidated beliefs in the context of general EU law. And soft law is actually not the first case, not at all the first case that the Court of Justice is addressing. There is a long tradition that starts at least in the 1970s, once again, without being complete. This list cites a number of major decisions that have been taken by the Court of Justice. And as you see from this list, there is a variety of instruments that the Court of Justice has had to address and consider, coming from various institutions within the EU. So we have cases concerning even minutes of council meetings being reviewed in the context of these decisions. We have a review of Commission internal instructions, we have codes of conduct, we have communication notes, we have letters, we have oral decisions, we even have announcements of decisions, and this is not cited in the slide intentionally, and because Gauweiler is really another very interesting case to consider from this perspective, where the Court of Justice ultimately decided to take up the case, even if it was not even a formal decision, just an announcement of something that was sort of in the pipeline. Now, this time we have instead a formal document of soft law. We have guidelines, and these guidelines were issued by the European Banking Authority in 2016, and they relate to product oversight and governance for banking retail products. Needless to say, but just to remember, these guidelines come from the joint position that was set out in 2013 from the three ESAs that sort of agreed upon the necessity of introducing product governance rules on a cross-sectorial basis. The first silence of EU legislation that took up this task was naturally MiFID, and then the MiFID standard was adopted in the insurance distribution sector, and then ultimately in the banking legislation by way of these 2016 guidelines. These guidelines are typically work with the comply or explain mechanism. They are addressed to national competent authorities that must publicly declare whether they intend to comply or not with the guidelines in their supervisory activity. And effectively, usually these guidelines have a very high level of acceptance. One can register cases where national competent authorities in different sectors, banking or capital markets or insurance, have ultimately opted out, but these are exceptions. The degree of acceptance of these guidelines is very, very high, also because, as Advocate General Bobek clearly set out in his controversial opinion to the court, there is a sort of mechanism of shame that may be shed upon authorities that publicly declare that they do not intend to abide, whereby the vast majority of national competent authorities ultimately declare that they will comply with the guidelines. Being the black sheep among many white sheep is always an uncomfortable exercise. And also another element that we have to consider is that ultimately these guidelines come up from national competent authorities, because even through the complex governance mechanisms of the ESAs are ultimately the result of a voting with different characteristics and mechanisms from the national competent authorities. So it would be a little bit queer, at least, to see that guidelines are issued by an ESA and then they are disregarded or not really complied with by national competent authorities. This would probably single out an anomaly in the functioning of the system, because these are not entirely top-down guidelines. They're sort of they have a common basis in the fact that they are supported ultimately by the voting mechanisms in the EBA. Now, in 2017, the French Autorité de Contrôle Prudentiel carried out its homework and issued the expected notice that they would comply with the EBA guidelines. But the Fédération Bancaire Française challenged this decision before the French Conseil d'État, and the French Conseil d'État in 2019 submitted a request for preliminary ruling to the European Court of Justice. Well, once again, this is another per se, without even going into the merits of the case, but I would like to point out that this is per se another very important example of the dialogue, of how the dialogue is going on among superior EU jurisdictions in the context of the banking legislation. I think this is interesting per se, because in our field of research, banking, financial legislation, we clearly see that there are mechanisms for dialoguing between the constitutional courts, the Court of Justice, administrative superior courts that are not really entirely in the line of what tradition has delivered us, which again confirms that European banking legislation is a huge laboratory of new experiences, even in this respect. But I do need to go into the merits of the case without losing more time. And the case was basically addressing 3 points. The first, very hot topic, whether the guidelines are valid or not. Second, whether they are included in the scope of Article 263, i.e. whether they can be subject to a direct action for annulment in front of the court. And third point, whether the FBF has locus standi to challenge these guidelines. Now, these are topics that have been touched upon in the previous jurisprudence. Most of them had already been discussed in the previous jurisprudence by the Court of Justice. And the ultimate result that comes out from the case apparently is not so disruptive. So one may even question why at the beginning I said this is a major case. The first time I said this, I got a lot of criticism from many of my colleagues saying it's not a major case. It's normal. What would you have expected from this decision? Because in fact, it is in line with the jurisprudence of the court that looks at the substance rather than the form of the legal act. It tells us whether something can be challenged under Article 263, whether it is capable of producing binding legal effects by looking at the substance rather than the form. But if you look a little bit more carefully in this decision, you realize that there are some quite innovative positions coming up that may also impact broader aspects of EU financial legislation. The first is on the validity of these guidelines. Now, the EBA came out entirely victorious from this first point, and basically we were all very happy about that, because wow, yes, the guidelines are valid. And again, you know, some people say that the Court of Justice sometimes is a little bit too protective vis-a-vis financial authorities and institutions. When it looks at the ECB, maybe it's a little bit lenient. Well, the Germans have been very critical in this respect. Let's think about Weiss, about addressing criticism to the court, being overprotective of the ECB, but also in other precedents, such as the UK case on the short selling regulation, we clearly see that the court tends to protect the institutional setup of financial regulation. And this again is in line with the precedents. But the fact, the new point is that in this context, effectively, these guidelines did not have a clear-cut legal basis. And the decision of the court is innovative because of its legal reasoning. If you look at the part where the court has to consider and say whether the guidelines are valid or not, what the court does is it looks at the legal basis of the guidelines and sort of looks at the different legal text. And when it comes to the central part of the decision, that also considers the Payment Services Directive, e-money directive, but ultimately the core part is CRD. It's really striking to look at the legal reasoning of the court, because the court reads the relevant provisions of the CRD, and at a certain point clearly meets a dead end, because there is no clear-cut legal provision in the directive that gives a mandate to the EBA, as we see in many other areas where the legal text, the directive or the regulation says the EBA shall or may or whatever. There is no such thing in relation to product governance, and the court has to acknowledge that. In paragraph 111, it says clearly these articles do not specifically mention product governance and oversight or the interests, objectives, and characteristics of consumers. And this is another interesting part, because consumer protection, oh my God, what does it have to do with CRD? And we can have another seminar on that later, maybe next year. And then paragraph 112, however, this does not mean that the robust governance arrangements referred to in Article 74 must be defined exclusively on the basis of those technical criteria. So there's a dead end, and the court turns rapidly 90 degrees right or left by saying, well, we have to sort of detach ourselves from the formal wording of Article 74, because we will find nothing there. And as a consequence, we must consider that the contested guidelines may be regarded as necessary to ensure the consistent and effective application of Article 74. These three paragraphs are a masterpiece of legal reasoning, and one of the several occasions that the Court of Justice gives us to test its capacity to turn a problem, an issue, into an opportunity. And the court has always done so since its origins, and naturally it's one of the most striking jurisdictions, innovative courts that we know of. And you see that the legal reasoning is really, I don't want to touch upon issues of economics, of policy. I'm really looking at the legal reasoning of the court, and I think this makes this case per se interesting and very innovative. The second point, so the EBA guidelines are saved from the accusation of being devoid of legal basis. They are valid, and the court then turns to the second point, which is whether they can be challenged under Article 2063. And here you clearly see the heritage of the previous case law starting from the 1970s, where the Court of Justice here again repeats its motto that if a text is devoid of binding force, it cannot be subject to an action for annulment, but it can be challenged indirectly in the context of a request for preliminary judgment. And this part of the case is in line with the precedents of the court. Per se, in fact, that's where I was criticized from being too enthusiastic about the innovative contents of this decision, especially on this point. But I have 2 points here that I need to raise and that I have more extensively discussed in my paper on the FBF case. The first is that maybe we should really consider whether Article 2067 and 267 and 263 are really on the same level. I mean, they do provide judicial review, they do provide protection in this respect, but we know that before you can raise a question for a preliminary judgment, you need a controversy in the country that, or in the home member state, and then the question must be raised in front of the national court, and then the question must be taken up, accepted, and the papers sent to Luxembourg, to the Court of Justice. So it is not exactly the same. Reviewing soft law under 263 or 267 may ultimately produce the same result, because if the guidelines are in breach of union law, you would end up with but the context is completely different. And I think we should really look at this point more carefully. The second point is that we have a ghost in this decision, and this ghost is Meroni. The Meroni doctrine is Meroni, Meroni is Meroni. It's a totemic item, and we still believe that Meroni is there, and we feel the presence of Meroni all along the case. And the presence is there because the court must necessarily say that the guidelines are not binding. Even if Advocate General, by citing amongst other the Game of Thrones, and that citation became viral in the opinion of Advocate General Bobek, I prefer to cite in my paper Katsuo Ishiguro's The Remains of the Day. I'm a little bit more romantic than Game of Thrones. But, Meroni, you really, I mean, you feel Meroni, but it's never cited. And this is, in my opinion, extremely interesting. Once again, from the point of view of the legal reasoning of the court. And it is striking that the court reaches this conclusion, has the capacity of reaching the conclusion by saying these guidelines are not subject to 263 because they have no binding value, without ever even citing, not even by chance, Meroni. But so you clearly feel that Meroni is there. It's an invisible host, and my personal opinion is that this decision strikes another very hard blow on what is left to Meroni, and it's like fighting against a ghost. You cannot touch a ghost, you cannot kill it, but you feel its presence, and the result of this decision ultimately may be another hard blow to Meroni, because what it does, by signing such a, I don't want to say a white check, but a very wide check to the ESAs in relation to the establishment of soft law, it clearly sort of represents another very hard hit to the Meroni doctrine. But the Court of Justice is very wise, is very cunning in never taking up Meroni directly in this decision, but you do feel its strong presence. Then there is the third point, the Fédération Bancaire Française, does it have locus standi to challenge the guidelines? And once again, here we have Giurisprudenza, and the decision of the court is partly innovative, not as innovative as the other 2 points, in my opinion, but it does have an interesting impact in the financial sector, because the court says, yes, the Fédération Bancaire, even if it is an intermediate body has locus standi to challenge these guidelines, obviously under a preliminary judgment. But we know how important the presence of intermediate bodies is in the financial sector, which is particularly active in setting up associations, federations of any kind, as a way to represent the interests of different stakeholders. Let's call them like that. And I think that in this respect, if you translate this decision into the real world, it's interesting because of the practical impact it can have in a sector such as the financial one, where the role of intermediate bodies are present. So we end up with this decision, and there are some points that I would like to point out before I finish my presentation. The first is that we clearly see, as also Maurizio De Bellis is writing in her very interesting paper, that the court has moved here from looking at a specific legal basis of a certain measure to the aims or goals that the EBA is pursuing in issuing its soft law, and particularly the guidelines. So there is clearly a shift that, not by chance, is similar to the approach that the court took in a completely different area, that of monetary policy, Gauweiler and Weiss, where the accent was placed in the decision of the court not on the instrument itself, but rather on the aims, on the objectives of a certain decision or of a certain instrument. The second is clearly that we see, as a consequence of the case, the possibility of an expanding role of soft law by the ESAs. They may feel that they are more flexible. The court says, I'm going to carry on, in any case, a very strong scrutiny of this soft law. It is not taking it lightly. I don't want to say that the ESAs will be able to do whatever they wish. This is not what the court says. It says we're going to take a very tough approach in reviewing soft law, but undoubtedly shifting from the formal legal basis to the aims or goals of soft law might imply expanding role, an increasing role of soft law in relation to the ESAs. And then we have the aftermaths of the case. If we consider ESMA, where already the presence of regulatory and supervisory tasks makes it quite a unique institution, and always bear in mind the ghost. We always have Meroni here. And with ESMA, the ghost is even more relevant, because it's not just a regulator, but it's also a supervisor, at least in certain areas. And I think we should also reason and look at this decision in the context of ESMA, that has its own specificities in this respect. And naturally, we clearly see that the role of the ESAs as regulatory bodies is increasing and going beyond probably what was what we could think originally. Also, the ESMA short-selling decision some years ago raised similar topics. Now, going to the conclusions, this decision is indeed a landmark of the court's jurisprudence. It has the capacity of shaping fundamental elements of the EU supervisory and regulatory architecture. It has far-reaching effects, including Meroni, Romano, etc. And it also might affect the approach to soft law in member states, how it is considered and applied by national courts. And then it leaves me with two questions. The first one is that I'm a big supporter of soft law, have always been a big supporter of soft law. I think it's very useful, but the question that I have is, does it raise an issue with the quality of legislation? Because we do have a hyper-regulated hard law environment, hundreds and hundreds of directives, regulations, and thousands of pages. And the need that we feel to constantly revert to soft law for filling the gaps, for interpreting, might raise an issue, might be a symptom of uneasiness of a system that looks hyper-regulated, but in fact is unable to capture through hard law the complexity of the environment. So maybe we should consider going back to a more principle-oriented approach towards regulation, leaving more space to soft law. But I feel a little bit uneasy because I see soft law is increasing in importance and relevance, but also hard law is increasing. So we always have gaps. We always have the need to supplement a hyper-regulated EU hard law environment with soft law. And then the last reflection is that I think it is not irrelevant that this controversy was triggered in an area where EBA tackles issues of consumer client protection. So my question is also whether there is this sort of signals out, and I think it does, an evolution on how client protection is intended in the context of CRD4 and banking union legislation, and also on a cross-sectoral basis. And the fact that we're talking in this major decision about consumer protection in the context of CRD4 and banking legislation marks it again as a very interesting case to consider. So thank you for your attention, and I leave the floor to the other panelists. Thank you again.
Thank you, Filippo, for this very clear explanation of the case, which raises a number of issues to be discussed now. As regards consumer protection, we have to organize another seminar, it's very important. So after the European Court of Justice decision, a number of issues are still there, of course, but at least we have received a clear guidance about the process to be followed to submit as a soft law to judicial review. This is a good point, I said before that the hybrid nature of the soft law is not a weakness, but that's a strength. And now we are entering into the field of the international financial standards, where this strength is clear because, as we know, the Basel process produces rules, soft law rules, which are applicable not only in Europe, but all over the financial world. So, Diego, you have the floor, please.
Thank you very much, Marino. Good afternoon, ladies and gentlemen. I'm very pleased to be present with you virtually. I would have been more pleased to be in Rome, but at least that will be for another time. And I would like to thank the organizer for having invited me. So I will try maybe to share my screen if it works, just to share my presentation. If it doesn't work, I would like to request kindly my colleagues, maybe from the university. Would it be possible to share my presentation, please? Because I'm, yes, thank you. Thank you very much. If we can move to the second slide. I just wanted to say that when we talk about international financial standards, which is an interesting form of soft law, as Marino started to say, you probably need to first, let's say, present the entity which is hosting the process, which is hosting the so-called Basel process for the adoption of international financial standards in the field of financial stability. And this entity is my organization, so the Bank for International Settlements. And in a few words, I think I'm unable to operate the slides unless I'm mistaken. So could we move to slide 3, please? Well, it doesn't matter. I think you will have a copy of my presentation at the end of my talk. So it doesn't matter, but I think at some point it will be useful to have a view on what I will say. So the BIS, and I'm sorry, and I think I have a broken voice now. The BIS is probably the oldest financial international organization, which has been established in 1930 to facilitate the payment of war reparations after the First World War. It's a it's a body of central banks with central bank as members, and its headquarters are in Basel, with offices in Hong Kong and Mexico City. We're a small organization of 651 people, and basically the mandate of the BIS is to basically act as a forum for discussion and cooperation among central banks. And it is in that context, in the context of a forum for discussion, that actually the Basel process for the adoption of international standards is taking place. But in addition to facilitate the adoption of international standards and facilitate discussions between central banks, the BIS is also acting as a bank to central banks. Thank you very much for the slides. Can we move to the next slide? The BIS is also acting as a bank to central banks, and also is also acting from time to time as agent to facilitate basically international financial operation, acting as escrow agent or collateral agent in the context of settlement between two countries. So I come now to the Basel process, which is the next slide. In the Basel process, you have a number of groupings which are active in the field of adopting standards in the financial sector to basically promote financial stability. But I will talk namely about the three first standard setters, which are the Basel Committee on Banking Supervision, the Committee on Payment and Market Infrastructure, the CPMI, which was formerly the Committee on Payment and Settlement Systems, and the Financial Stability Board. I will not talk today about the rest of these bodies because they are in a way less important for the sake of our discussion about soft law. So the first, if we move to the next slide, the first committee important is the Basel Committee on Banking Supervision. That is a committee which has been established already since 1974 after the failure of the German credit institution Erstadt, which gave rise to development regarding currency risk because it was engaged in a number of settlement operations of FX transactions where basically one leg was paid, the US legs, and the Dutch mark was not paid. So it basically reinforced the idea that we need to ensure a PVP process and a DVP process for security systems. And basically following that, there was a need to ensure that there was a broader international harmonization and cooperation in the field of banking supervision. And that is the aim of the Basel Committee, which is composed of 28 countries, which is chaired by the current governor of Bank of Spain. And it's the primary global standard setter for the organization of the prudential regulation of banks. When you talk about Basel process or Basel Committee, you immediately think about the famous Basel I, Basel II, Basel III rules or accords, which have to do with the regulation of capital adequacy, the solvency ratio, the liquidity ratio, all these rules which have to do with ensuring that the capital of banks and their credit basically liquidities are sufficient to meet their exposures, their debt. So basically it has to do with that, but the Basel Committee is also adopting principle not only on the technical field for ensuring precisely this type of capital adequacy, but also to reinforce banking supervision or corporate governance principles for banks, you know, even in the field of compliance or audit, for instance. And that is a committee which is a grouping that doesn't have a legal personality. It's a grouping of central bank and bank supervisors, basically meeting at the BIS, and which functioning is facilitated by a secretariat that is composed of BIS people, BIS staff people, basically helping the committee to do its work. Now, the mandate, I think we mentioned that already. We can move to the next slide. So I said that basically on slide 8, yes, we have basically the Basel Committee, which is establishing and promoting global standards. So on the next slide, if possible. So it is establishing standards which constitute minimum requirements. So it is possible for countries to go beyond, to adopt more stringent or more comprehensive or more tougher standards, but this is a minimum. There is also normally an agreement on the implementation phase, so that basically there is a phasing process for the implementation, and the idea is to have at the end of the process every country participating to the implementation process having translated into national rules the Basel Committee standards. And this is an illustration of soft law in the field of financial stability, because the Basel Committee doesn't have a supranational authority. It doesn't even have a legal personality, as I said. It's a de facto grouping of regulators and central bankers, which are meeting to basically reach a consensus about how to regulate banks and other financial institutions in certain areas, in order to make sure that they are more resilient, they are more sound financially, in order to avoid precisely the type of risk that countries want to avoid, and basically have a run on banks. So the decisions of the Basel Committee are not binding. They don't have legal force. They don't apply. They are not binding on the countries. They are not binding directly on the banks, on the financial intermediaries. The Basel Committee relies on its members, authorities, to basically implement at national level what has been agreed at the international plan. But of course, in doing that, the Basel Committee wants to ensure that there will be a timely and consistent implementation. So there is a peer review process of the implementation of Basel standard to make sure that we avoid regulatory distortions, and that there is, as much as possible, so not always guaranteed, a level playing field among international banks. So the next slide, please. Will just highlight the fact that, given that the Basel Committee is a restricted body, you need to make sure, and that is an issue obviously with soft law in that context, you need to make sure that those countries, those authorities which are not part of the Basel process or the Basel Committee process will nevertheless also have a possibility to contribute, and the possibility to also implement those principles. This is why there is a consultation process with countries and authorities which are not members of the Basel Committee, to get their input, and also to try to help basically implementing those standards. But the coordination process doesn't stop with regulators in other countries. It is also something that is taking place with other financial standard setters, like the IOSCO, basically, or the Financial Stability Board, or the IMF, and the other bodies within the BIS Basel process, like the CPMI or the International Association of Insurance Supervisors, IAIS, which is adopting standards for the insurance industry. So now, if we come to the other the second body that I want to comment on in terms of international standard setting, which is the next slide. This is the Committee on Payment and Market Infrastructures, CPMI. So that was a former CPSS that was well known in the field of security settlement system and clearing system and payment systems. That was established after the land fallacy report on interbank netting schemes in 1990. And basically, its primary task is also to promote now in the field of market infrastructures, payment system, again, security settlement system and clearing systems, the, kind of common denominators, common requirements to ensure a safe, sound, and efficient functioning of those market infrastructures. And for this to take place, the CPMI is adopting, again, standards, international standards that need to be translated by national authorities in the field of those market infrastructures, which have been consolidated in the Principle for Financial Market Infrastructures in 2012. Now, if we come with the next slide, please, if we come to the combination of all these standards, it can be very tricky, very complex, because I've seen that from the other side when I was in the private sector with Euroclear Bank as a recipient subject to these standards. It can be very tricky because you have, for instance, the 19 CPSS IOSCO recommendation for security settlement systems in terms of legal soundness, in terms of DVP, in terms of basically finality, this type of standards. So basically, they are setting principle at international level that need to be translated at national level. But then you may also have within the Euro area at least standards for the use of security settlement system by central banks member of the Euro system, because they will say, well, we will only use for monetary policy operation those systems which are complying with our minimum standards, so that basically monetary policy operation can safely be settled. So those standards may or may not be the same, may or may not overlap harmoniously. And then on top of all this, you also have national regulatory standards, which may be adopted by each authority responsible for, in my example, security settlement systems, which are not only the national translation of those principles, whether CPSS, IOSCO, or whether in the context of the Euro area, Euro system standards, but they can come with their own additional requirements. So that is, of course, it's some of these standards, the international standards, especially the CPSS, IOSCO, or even the Euro system, are not necessarily directly binding on the system, but you have consequence if you don't comply with them, because then basically there will be some stigma, some reputation risk. If you don't comply with sanctions, you will be somehow listed as not complying with that or that sanctions. It will be mentioned in FSAPs from the IMF. So this will be known. Security settlement systems have to also disclose whether they comply or not with the applicable standards. So there will be some market incentives to comply, because otherwise you may be basically less used by market participants who will feel that their own regulators will also have an issue in having them using those systems which are not fully compliant. In addition, at national level, certain systems, therefore, may not get their operations or their projects in terms of settlements be accepted by the national authorities, which may have indeed a right to approve a certain project or certain operations before going live. So therefore, it will be basically blocked. And they can even be fined in certain countries for not complying with applicable standards. So there are serious consequences in not complying with those standards. And the challenge, therefore, is to ensure that the consistency between all these various standards applicable to the same operators and most of the time to the same type of features, to the same type of operations, if you want. So that is of course an issue with international standards. Now I want to come to the last international standard setters thank you so much for the BIS under the BIS aegis, which is the Financial Stability Board, which is probably the most important one, because the Financial Stability Board is the body which is basically is the overarching authority which has to do with the coordination at the international level of the work of international standard setters and to advise in meeting regulatory standards. So they have the mission, especially since the London Summit in 2009, to not only to promote financial stability, but also to make sure that the work of international standard setters is, let's say, internally consistent and will also achieve the goals which are set by the G20 leaders and ministries of finance, which is the body to which the Financial Stability Board is reporting. And from that perspective, the FSB has probably a higher accountability than the other bodies working under the aegis of the Basel Committee, because under the Basel process, because the Basel Committee on Banking Supervision and the CPMI only report to a group of central bank governors, while by contrast, the Financial Stability Board is reporting directly to G20 ministries of finance and leaders. So that is a difference in terms of governance. But the Financial Stability Board is also a standard setter of its own, because they also regulate, they have also recommended a number of standards for instance, for the resolution of financial intermediaries, also for the regulation of what is called the Global Systemically Important Financial Institution, the GSIFIs, and also for already very early in the wake of the last financial crisis, for the regulation of bonuses and sound compensation schemes, because it was something that basically triggered the attention of leaders because they thought that the excessive compensation schemes were an incentive of taking undue risk in the context of the last crisis. So if we come to the next slide, please, thank you so much. The FSB has some criteria to basically determine which are those standards which are those that the FSB should promote. They must be relevant, of course, and critical, universal in their applicability, flexible enough to be taken by each country, and broadly endorsed by international bodies, with also sufficient consultation of external stakeholders, not something only cooked behind closed doors, and with, of course, a possibility to assess their implementation at national level. And the example of that is just the next slide, please. Of course, it will be probably difficult for you to capture that on the screen, but you will find them on the website of the Financial Stability Board, and they will be available. Thank you so much for increasing the size. So you can see that there are standards in the field of transparency, in the field, of course, of financial regulation. So that those are the banking supervision, also for Islamic finance, securities regulation, insurance supervision. And then you have what relates to the market infrastructure, so crisis resolution, insolvency, accounting, so the IFRS principles, which are well known as well, principle for financial market infrastructures, the FATF recommendations on money laundering, on prevention of money laundering, and of course the key FSB attributes for the resolution of financial institutions. So
Diego, sorry to interrupt you. We are running out of time. So
no, I'm finishing. So basically, those principles need to be implemented by FSB members, and in order to help people to implement those standards, we have on slide 16, please, if we can move to slide 16, which is the penultimate one. We have the Financial Stability Institute, which is also helping regulators to understand. It's a kind of learning body that is helping regulators to basically understand the standards which have been adopted. Now I come to the last slide, which may probably be discussed further during the panel, but I want nevertheless to set the scene, which has to do with the pros and the cons of the international standard process, which is about the well-known consequence of soft law versus, legislation versus hard law. Well, in the field of international financial standards, for the sake of regulating financial stability, of course, soft law standards are somehow better because you can reach more flexibly a solution at international level. And even though it may take years, it will be still faster than what you can achieve by way of a treaty or by way of convergence of national legislation, because we're talking not about only a region, but at international level. So it's pragmatic and it's relatively flexible. But of course, it cannot be enforced directly against institutions. You need to have national authorities translating them. But there is some incentives, as I mentioned, in the context of security settlement systems, by which there is incentives to basically comply with these principles. And the drawbacks, obviously, are the fact that, as usual, you don't have the full democratic legitimacy. There is no review by parliament. There is no review by full national authorities. This is done by the expert bodies. So that from that perspective, that is a drawback. And obviously, the fact that it will be left to national authority to implement within, of course, their own framework will trigger unavoidably some differences in implementation. So there will be less predictability and legal certainty depending on the way countries are implementing those standards, which, by the way, is the same thing when you implement a national European directive, because you may also have variations in the implementation. And finally, the last drawback that I see, but there are many others, is that obviously, as I mentioned, you cannot have all authorities around the table. So obviously, this is something that needs to be then further coordinated with external parties. So I'm stopping here, Marino. Sorry for having been too long, but this was a complex issue.
Thank you, Diego. I just want to remember what you said in your last slides, the pros and cons of different regulatory tools. But let me add that in the European framework, the role of the European Court of Justice, as laid down in the last decision of the Court of Justice, offers a way for the legal challenge that is there is no equivalent in the international financial standards, of course. So we have one more added value in the European Union, the possible legal redress in the case of soft law, which is not in line with the legal foundation, So, Concetta, you are the chair now for the second part of the seminar.
Thank you, Marino. Thank you to the two speakers. Really, I would like to thank them for having given us some very important arguments to discuss in a very frank way. Also, I guess that it could be useful for the panelists that are coming. I would like to thank and to introduce very briefly the participants to the panel, to the round table. They have a long experience in the field, all of them, and a specific experience with this case. So I'm very pleased that they have accepted to participate. Inci Metin works at the EBA legal department, so she knows by heart the case at hand. And Donato Messineo from the Bank of Italy legal department will give us the perspective of the national national soft law, the proceedings and the outcome of these of those rules, and then Amélie Champsière that could I don't know if I pronounced correctly your surname. Sorry for this if it was not. That from Cleary Gottlieb in Paris, a law firm, but she will give us the perspective of the banking sector from the market. What thinks the market about those guidelines, soft law, international standards. And finally, but not last, Maurizia De Bellis from University of Rome, a colleague of mine that has published intensively in this field. So again, an academic perspective to currently react to some extent to the one exposed by Filippo. I guess Filippo will be pleased to discuss. So I hope I start the discussion. I am sorry to remind to the speakers we have 10 minutes, a little bit more, not too much, in order to give room for Q&A session, even short, at the end of the seminar. Thank you very much again. The floor, Inci, the floor is yours.
Thank you very much for the opportunity to speak here today. I feel very honored. So let me start by saying, of course, from the EBA perspective, we were very pleased with the judgment. And the whole procedure, we didn't take it light at all. So we worked very hard. We provided lots of justification. And I will provide some of this to you here. So I hope this will make it easier for you to understand our position. Yeah, on Meroni, I will speak later a little bit. I have my opinion why it hasn't been referred to. I think they had good reason not to refer to it here, but Meroni is fully in place and it's fully there. And we are fully committed to the Meroni doctrine, and we think it's very important. From the EBA perspective, we take also the criteria under which we can act, our scope of action and the legal framework, our powers, very, very seriously. Obviously, the legal department even more. And we didn't take it, as I said, lightheartedly when the court took one of our guidelines under their scrutiny. And what for us, I mean, we are before I go into the judgment, just to remind what already Filippo said, we are a supervisory regulator. And we have certain objectives and tasks that we have embedded in the EBA regulation. We have to make sure that the financial markets function orderly. There is a couple of objectives. I don't want to mention all of them, but one of them is also enhancement of customer protection and also consumer protection. We work on a very, very technical level. So we all know why we were founded. I mean, we were founded there. We provide I mean, not we from the legal department, but my colleagues, they provide all the legal, all the technical expertise, supplement the laws. And under Article 16 of our founding regulation, which is the empowerment to issue guidelines, it is our job to ensure that supervisory practices, including the ECB supervisory practice, which is also a competent authority, is consistent across the EU, and also that the union law is applied consistently and effectively. This is our job. Now, what does this mean? So I think what the court did, they took the framework, they looked at it, and they crystallized how to scrutinize, how to look into what guidelines can do and what we have to do when to check the validity. And the first thing they said, of course, it is non-binding. You can comply or explain. Therefore, it is non-binding. Okay, they said this. Then they say, but it doesn't mean that this is just soft law and this is unimportant. They said it can have a significant impact on the market. And we at EBA know that. It's not like we're like, oh, it's soft law, we can issue whatever we want. We know that this can have, it is non-binding, but it can have a significant impact, and it will change practices of supervisors and financial institutions. Also, the court repeated again that guidelines and recommendations will be taken into account by national courts when they interpret union law. And therefore, the court says guidelines are important, and therefore they are reviewed by us. They are not just reviewed, they said that they will apply rigorous judicial review on guidelines. And this is and we take this very seriously at the EBA. So now, just to repeat what they said, the two steps of how to review whether guidelines are within the empowerment. So they look at the scope, and when I'm often, I want to emphasize this a lot, that there is 2 paragraphs in our scope of action. And the second one is often omitted and often forgotten. Not in this circle, I know this, but I have to emphasize this. So the first one in our scope of action enlists all the sectoral acts which fall in our scope of action. So the CRR, CRD, PSD, Mortgage Credit Directive, and so on. Now there is another paragraph in our scope of action, and it says in the EBA regulation, in this paragraph, that the EBA shall act also in areas not directly covered but by those sectoral acts, if the actions of the EBA are necessary for an effective and consistent application of those sectoral acts. We have pointed out this to the court in our observations, and we are, of course, the court picked it up because it's there, black on white. So it means we have to show that there is this necessity, and that what we are doing is always linked to the sectoral acts, but also in areas that are not directly covered. And the second stage of the court said, of course, when the EBA is acting, they are not only EBA acting within their scope, but they also have to act within their overall legal framework. So the first act that we have to look at is the EBA regulation. The empowerment to issue guidelines that I mentioned before is Article 16. Does the guidelines ensure consistent application of union law, and cumulatively, does it ensure consistent supervisory practices? This is the job that we have to fulfill with guidelines. But not only that, not just in the scope and fulfilling this empowerment, but also directed towards the objectives of the EBA that I have mentioned before: functioning of the market, enhancement of customer protection. Other tasks that the court also referred to on I think they also refer to credit taking and all sorts of other tasks. So all of this has to be proven and shown by the ESAs when they issue guidelines. So the burden of proof is on us. And now the big question was, because these guidelines concerned retail product governance, and we based it on several of sectoral acts, is this now necessary, what we wrote in there, to achieve effective application of those sectoral acts, the CRD, the PSD, Payment Services Directive, and the Mortgage Credit Directive. Now, we have provided a lot of justification to the court in our observations why this is necessary, what we did. And I cannot emphasize enough that for the part of CRD, we base this on internal governance and internal controls. This has nothing to do with corporate governance. It's not about business decisions. It is about internal controls. And now the question, what was the justification? Of course, this provision is very general. You have to have a robust internal governance controls mechanisms as a bank in order to be robust from a prudential perspective. But does that mean that EBA can only speak about this in general terms? What if there is concrete risks that we identify on a general level? And also, if you look at the annex of the CRD, all the products that banks offer, all the activities that are covered, does this not include consumer products? I think it includes any product, anything, any activity that a bank does. Now, in this case, all three ESAs had identified a serious risk for banks stemming from misconduct in the area of retail products. These risks were quantifiable. There were studies, there were researches. We have looked into that, and it was a particular cross-sectoral concern. Now, from this mis-selling to consumers, there was a serious risk stemming that affected banks, and these risks could effectively be controlled by purely internal mechanisms, internal controls. So basically, if you say, as a business decision, you say, I am a bank only for students, for student credits, then the only thing that the guidelines would be saying, think in your internal processes, consider this target market. And I think that that we could explain to the court why this risk has been identified before by all three ESAs, and then the EBA took this and could show why tackling this in a very general way that we put a basic step, so to say, in the internal processes of a bank, why this was falling under the provision of Article 74 of the CRD, also considering our scope of action that we can cover areas not directly mentioned in the sectoral acts if they are important to achieve the actual purpose. So, what?
Inci, may you go to the conclusion, stick to the time.
Oh my God, the time flies. The time flies. My notes seemed so short, and now I'm talking.
Sorry,
okay, I will skip just maybe on Meroni. So as I said, I think Meroni is there. Meroni is strong, and we believe in Meroni. But I think that there is one important difference in this judgment. So here, the court looked whether the EBA acted under the boundaries that the EBA is given, the criteria that the EBA has to meet. And they didn't look whether the empowerment itself followed the Meroni doctrine. This was not the question of the case. While when you look at the Meroni doctrine, it was always about whether the delegation and the empowerment was legal. So this is one important difference, I think, why it was not mentioned. And the second point is that I also noticed in the Meroni case, the Meroni concerned a binding direct executive decision. If you look at, for example, the short selling case, this concerned intervention powers of the ESMA, prohibition powers of the ESMA, which are directly binding. Here we have guidelines. So I think this is also an important difference that we have to mention. Yeah, I'm sorry, I cannot speak about consumers, but maybe just one little thing. What we put in our observations to the court, we believe there can be one rule that says, for example, in your internal controls, check that you have identified what your target market is. This rule can follow the purpose and the aim of CRD, namely having robust internal controls by banks. And it can also follow the aim and have the effect that consumers benefiting from that, like under the Mortgage Credit Directive. So I know, I see, Conchetta, I have to really sum it up now. Thank you very much for this opportunity. We will keep sticking to the limits that the court set us, and we will keep trying to provide good guidelines for the market. And thank you for the opportunity.
Thank you, Inci. First of all, for the enthusiasm that you put in your job. And we are happy of this first, as citizens, sincerely. We need, Marino, what do you think? Another seminar also to understand if Meroni is a ghost or is there, as Inci is saying. I think that we will have a thriller webinar. Then,
I'm afraid that Meroni is there. Meroni is there. It's not just a ghost. However, next time we will speak about it.
We should think about. Thank you very much. And now, Donato, the floor is yours. Please stick to the time. We have discussed it yesterday.
Yes. Good afternoon, everyone. I would like to thank the organizers for this opportunity to reflect on the issue of soft law, because it is a highly topical issue, and not only because of the recent developments in case law discussed by the previous speakers, but also because of the evolving practices of national authorities. I will briefly report on the practice of the Bank of Italy with reference to two areas, namely the implementation of soft law arising from the European supervisory authorities, especially, of course, the EBA, and the adoption of soft law on a standalone basis. In fact, not only does the Bank of Italy issue soft law in order to follow ESA's guidelines and recommendations, but it also adopts soft law on its own initiative, if you will, in the matters on which it has regulatory power. And this especially applies to the fields which remain outside of the scope of the European Banking Union, but not only, such as customer protection and anti-money laundering. The two phenomena look similar, but the legal basis is partly different. And indeed, complying with the EBA's soft law is the default position, so to say, for the Bank of Italy under EU law. In turn, resorting to the adoption of national soft law instruments to that end looks pretty obvious. It certainly ensures consistency and even a symmetry between the Italian and the European legal system. However, this is a recent practice. It is only since August 2019 that the Bank of Italy has modified its policy regarding the compliance with the EBA soft law. The new policy was made public through a communication published on the bank's institutional website in August 2019. Before then, the Bank of Italy used to transpose EBA guidelines into national law by way of amending the regulatory acts in force. Of course, this doesn't apply to each and every EBA guidelines. Some guidelines are only addressed to competent authorities and do not entail any modification in the operation of the banking business. The approach followed by the Bank of Italy until 2019 had both strengths and weaknesses. The main benefits were twofold. First, This technique provided the chance to amend all of the relevant provisions in force so as to better accommodate the newly introduced standards. Moreover, implementing the EU guidelines through actual sources of law made their enforcement straightforward. And indeed, non-compliance with the EU guidelines by the supervisees may directly lead to restrictive measures or penalties by the Bank of Italy only upon condition that such guidelines are transposed into proper regulations. This doesn't mean, however, that the soft law of the Bank of Italy arising in the form of guidelines lacks any legal value at all. I will come back to this later. Of course, there were also drawbacks in the systematic implementation of the EU soft law by way of amending banking regulations. First of all, under the Italian legal framework, in order to enact or to amend the regulation, the Bank of Italy is required to previously undertake a public consultation with the stakeholders and an impact assessment. However, such activities are already carried out by the EBA for the purposes of the adoption of its own soft law. Therefore, carrying out these steps once again at the national level might have made the procedure unnecessarily complex, especially in situations where poor or no margin of discretion is left at national level. And it's more and more often the case, as mentioned by Marino Perassi in his foreword. In addition, it must also be noted that the European Central Bank has no regulatory power in matters of substantive banking law, and therefore it implements EBA guidelines through soft law instruments addressed to significant institutions. As a consequence, in the event that the Bank of Italy had continued to implement EBA guidelines through regulations addressed to less significant institutions, this would have perpetuated an asymmetry between the two classes of entities. A discrimination, by the way, which doesn't seem to be justified on grounds of the different sides of the entities. This is the reason why already prior to 2019, the Bank of Italy had resorted to soft law addressed to LSIs in situations where certain matters had already been covered by an ECB guidance addressed to significant institutions. In light of the drawbacks that I've dealt with so far, in 2019, the Bank of Italy decided to comply with EBA guidelines in a different way than it had previously done. In principle, the Bank of Italy no longer amends secondary legislation, but it published communications in a special section of the website stating its intention to comply with this or that guideline. For each EU soft law instrument the Bank of Italy declares to comply with, a communication is published in a standardized format. Only as an exception to this general practice, the Bank of Italy is still committed to amending regulatory acts on certain occasions. This happens when following EU soft law requests the introduction of actual obligations on the part of the supervisees, and also in cases where compliance with the EU soft law requires coordination with existing regulations. The case of soft law adopted by the Bank of Italy on its own initiative is different. Nobody really doubts that the Bank of Italy has the power to issue soft law instruments by now. But before the Bank of Italy actually started to produce soft law, in-depth analysis were carried out regarding the legal soundness and the legal basis of this practice. And indeed, the Italian banking law expressly vests the Bank of Italy only with the power to adopt regulations. No explicit act of parliament provides for the issuance of soft law by the Bank of Italy. However, the absence of an enabling clause in the language of the law doesn't imply as such that the Bank of Italy lacks the power to adopt soft law. Generally speaking, the Italian Council of State, starting from a judgment in 2015 concerning public contracts, is of the opinion that supervisory authorities have the power to provide interpretive indications in their areas of competence. According to the Council of State, their guidelines have the value of, quote, objective standards of conduct for those operating in the sector, end of quote. And that unjustified disregard for such guidelines is a clue that perpetrators acted with negligence. Now, the Council of State didn't state reasons for its stance. However, it seems reasonable to consider the power of certain authorities, including the Bank of Italy, to adopt soft law as an implicit power. I personally believe that this power may be traced back to a number of general rules, and in particular to the principles of proportionality, non-discrimination, transparency, and good administration. Proportionality, because soft law only provides guidance when there is no need to introduce proper obligations in order to achieve statutory goals, resulting in a lesser burden for the supervisees, of course. Non-discrimination, insofar as the authority will not be able to depart in a particular case from the general position it articulated in soft law without stating adequate reasons. Good administration, because soft law may increase the transparency of the administrative action and may foster the predictability of supervisory measures. However, a general question arises as regards sanction mechanisms for disregarding the guidelines. In fact, it is clear that disregarding soft law cannot be sanctioned as such. Not taking a guideline into due consideration doesn't amount in itself to a violation of law. However, the case law of the Council of State, I referred to before, leads to recognize at least a degree of normativity of the guidelines, since, as I was saying, disregarding the guidelines may be a clue of negligence. There is no automatic consequence here, of course. For instance, recent judgments of the same Council of State on healthcare matters clarify that compliance or not compliance with the guidelines released by the Ministry of Health cannot be relied upon as an absolute standard of review in the assessment of medical liability. On the whole, it seems that the case law of the Council of State is starting to lay the foundations for a legal basis through which soft law may gain some hardness. Concetto, tell me, sorry.
I was reminding you the minutes left.
Oh yes, I'm really near the end, sorry. And this makes it possible to overcome some of the doubts raised years ago in the academic debate. I'm thinking of the memorable 1998 article on the undesirability of soft law, in which Jean Clabbers wondered, quote, what does it mean to say that somehow a soft law instrument governed matters? In reality, no one knows. Today, we are beginning to know more. We are able to answer. All in all, interpretive guidelines show some similarities with a type of act that has been well known and widespread for some time now. I refer to administrative circulars. Acting in contradiction with a circular alone doesn't make an administrative measure null and void. However, disregarding a circular is deemed by courts as a clue of a possible misuse of discretionary power. Now, despite the different nature of circulars, which are internal acts only applicable within the inner sphere of the administration, an analogy can still be grasped with the guidelines as to their effects, since disregarding a guideline is considered as a clue of negligence on the part of the supervisees. This presumption is rebuttable. Of course, it may be overcome by demonstrating that different safeguards were adopted, equivalent to those recommended by the authorities. At the end of the day, the developments in recent case law are proving that the detractors of soft law were wrong. Some of them argued that the spread of soft law was expected to set technical authorities free from the control of the judiciary, to weaken their accountability obligations vis-à-vis parliaments, to endanger the rule of law. But on the contrary, analyzing the case law shows that in 2016, Giuseppe Morbidelli was right in pointing out that, paradoxically enough, soft law is a no law which may contribute to the certainty of law. And indeed, codifying best practices, sharing supervisory expectations, providing guidance, and so on and so forth, the authorities in first place bind themselves to consider a certain behavior as appropriate, and as such, unable to give rise to liability. This creates legitimate expectations for the supervisees. On the other hand, deviations will still be acceptable provided that they are consistent with the supervisory purpose. I conclude. more crucially, perhaps, the whole articulation of the particular type of soft law issued in the context of the European Banking Union underpins actual legal obligations. The hard obligation to either follow certain new instruments or motivate a decision not to do seeks to posit itself as a halfway house between soft and hard law. And the chances are that such process is already casting a spillover effect also on the degree to which purely national soft law is actually capable of shaping the conduct of the supervisees. Thank you for the patience.
Thank you very much. No, we are very happy to hear all these very interesting arguments you have elaborated in, but I would like to take time for the other two panelists, two ladies. First, now we have heard from authorities that they have said, told us a lot of very good things about positive aspects about soft law. And now I would like to understand from the market, from Amélie, first, if it's so easy the job to comply or explain, or it's difficult. Thank you very much for Amélie for being with us, or even if I know that you are far away. Because
Many thanks, Concetta, for the opportunity to speak, and I'm very glad to be in this a very prestigious company. I will indeed speak about the point of view of the market, and because soft law raises specific challenges for market participants and banks in particular that are adversely affected because of the use by the authorities of soft law instead of hard law in a number of circumstances. And I will not go to the validity of the approach of soft law, which in many cases is not in doubt. But the problem is that the use of soft law in many cases deprives banks of the right to an effective judicial remedy, despite the fact that this is a fundamental right protected by the Charter. And so when banks are faced with a decision that is adopted pursuant to guidelines or soft law generally, there are two questions. The first one is, can I challenge the guidelines or the soft law itself on the grounds that this soft law is invalid or otherwise contrary to EU law? And then the second question is, if I cannot challenge the guidelines, can I challenge the application of the guidelines in that case? And so in particular, the fact that through an individual decision taken in application of some guidelines, the authority has failed to apply its own guidelines. And I will start with the second one, because this actually, in that case, the case law is actually more settled and pretty clear at this point. The Court of Justice has consistently found that guidelines are binding on the authority itself. And that is constant in the case law of the court, including with respect to competition cases. One example is the Kotnik case, where the court decided that the Commission's guidelines, the communication on state aid in particular, while they were not binding on the member states, were binding on the Commission itself. So this means that the Commission can depart from its own guidelines in a way that is more favorable to the market participants, but it cannot depart from its guidelines in a way that is unfavorable, because that would consist in a breach of the principle of legitimate expectations. And if we look at the first question that I mentioned, which is, can the market participants challenge the guidelines themselves? And that was the topic of the FBF case. And that case was premised on the fact that these guidelines could be challenged on the basis of Article 267, so in the context of a prejudicial question, rather than in the context of a direct challenge under Article 263. What I want to highlight is that there is another possible route, in my view, to challenge guidelines or soft law directly, which is Article 277, and that is the possibility to challenge an act of general application by way of objection. And the guidelines are an act of general application. They are not hard law, but they are an act of general application. And so even if they cannot be challenged under Article 263, the market participant can challenge the guidelines by way of an objection in the context of a challenge under Article 263 against a decision that would be taken pursuant to these guidelines. And if in the context of this challenge by way of objection, the guidelines are found to be invalid or contrary to EU law, the guidelines will still stand. They will not be annulled because, of course, this is not 263, but they will be found inapplicable to the case at hand. And the part of the decision that derives from the application of the guidelines will then be annulled. And I wanted to challenge that because to highlight that, because I don't think that's something that derives from the FBF case, which again was based solely on the prejudicial question under Article 267. To give a concrete example of this, I will take the example of the SRB that adopted a policy with respect to MREL, so the minimum requirements for own funds and eligible liabilities. And this is an act of general application, which is not intended in itself to be binding. And so whether or not it can be challenged will be assessed under the criteria that are developed in the FBF case. But regardless of whether one can challenge this policy directly, one can challenge a decision to set MREL that is adopted pursuant to that policy. And in the context of the challenge against that specific decision, which of course is binding and challengeable under 263, challenge the legality of the policy under which it is adopted. And if that challenge is successful, the policy should be disapplied to the case at hand. Another point that I want to make is that all soft law is not created equal. There are many different kinds of soft law, and they do not necessarily have the same effects on market participants. If we look at a recommendation of the ECB functions often by way of recommendations, and even within the recommendations, not all of them have the same legal effects. A few years ago, the ECB adopted a recommendation with respect to the provisioning of non-performing loans. And what it did was to invite banks to provision these NPLs in excess of what was strictly required under the CRR. More recently, in the context of COVID, the ECB issued another recommendation inviting, this time, banks not to distribute dividends. And I think the legal effect of these recommendations was actually different. If we look at the recommendation on provisioning, it was indeed only a recommendation. And while we know that the ECB exercised a fair amount of persuasion for the banks to take the provisions, a number of banks simply said no, so comply or explain. In that case, explain and not comply. So what the banks said, some of them, not all, was, well, thank you for the recommendation, but we don't think it's appropriate because our portfolio is already sufficiently well provisioned in a conservative manner, and so there is no need to provision in excess of what is required by law. And if that's the case, and the banks can effectively not comply by explaining, then of course the act in question is not binding. In the context of the recommendation on dividends, this was a bit different. And I don't think that it was challenged in court, but the analysis would have been interesting. If we look at the criteria of content of the act, context of the act, and then powers of the authority to determine whether or not the act can be challenged under 263, in that case, the ECB, in terms of powers, did not, in fact, have the power to suspend dividends because the ECB is required to apply national law. And under the national law of the member states, there is not a general power to suspend dividends. When that power exists, at least it's the case in France, I think also in Italy, it must be justified by the specific situation of the bank. And so the ECB did not have the power to suspend dividends in a binding way across the board for all banks of the Eurozone. If we look at the criteria of content, the recommendation was clearly a recommendation and was inviting the bank, not in wording that was mandatory, to respect the text. But if we look at the context, this was a time of urgency, of solidarity, and any bank that would have started to distribute dividends in that context, despite the recommendation, would have taken a pretty big political or reputational risk. And so in that specific context, there is an argument that the intention of that recommendation was to be binding, and that its effect was to be binding on the banks, and that it actually was adopted in the form of recommendation only because the ECB technically did not have the power to impose it through a binding act. And in those types of circumstances, I believe that in order to maintain the bank's right to an effective remedy, these types of acts should be able to be challenged under Article 263. Another example of that are Q&As of the EBA. They provide an interpretation by the EBA of a specific text. And the EBA is very careful to say that only the interpretation of the Court of Justice is definitive. But then the question is, how do we get the Q&A before the Court of Justice? And here also, the overall context of the Q&A must be taken into account in light of the principle of effective judicial remedy. Once a Q&A is published, what it does is it provides the EBA's interpretation of the text on which the ECB or other competent authorities then rely in order to apply the law. So can a bank not comply in that case? And the answer is no. And I think Mr. Messineo also said the same thing, because it would be taken into account as an element of negligence, which means that the bank could be actually sanctioned for not complying with the interpretation set out in the Q&A. And the bank, if it does not comply with that interpretation, does take the risk of being sanctioned and will have the opportunity to challenge that interpretation only in the context of a challenge of the sanction decision, which is not a realistic risk that any bank wants to take. So as a practical matter, the Q&A is binding on the bank, and the right to a judicial remedy for these interpretations is not entirely clear, and one could even say does not exist. And we face a similar situation, for instance, in the context of state aid decisions in phase 1. These decisions do not technically impose commitments on the market participants, or at least the commitments are technically voluntary, but the failure to comply with those commitments results in the withdrawal of the aid. Therefore, as a practical matter, there is no option not to comply. And if that is the test, then these different acts should be subject to challenge under Article 263. And my conclusion here is that the FBF judgment is interesting, but soft law can take many forms, and the conclusions of the court in that judgment are not necessarily definitive with respect to all cases of soft law. And we need to ensure in those future cases in which hopefully soft law will be challenged, that there is a right of effective judicial remedy that is guaranteed with respect to any soft law that actually directly affects market participants' legal position. Thank you.
Thank you very much, Hameli. Thank you very much also because you have highlighted a very important point. Under the umbrella of soft law, under this denomination, there are a lot of different things probably. And also to some extent, it depends also on the powers that the authorities, different authorities, enjoy in this field. So a very important point, and also because you have highlighted the point of these are rules that apply, that give a burden over the market, and so we should always think about the fundamental right of challenging these kind of decisions. Thank you very much. And now, Maurizia, the floor is yours to give again the perspective of the academic sector in this field.
Thank you, Concetta. Thanks to both you and General Counsel Perassi, who's not here anymore, but in any case for the invitation to join this extremely interesting and timely debate. I will divide my intervention in two parts, and the first part refers to the FBF judgment. So soft law at the EU level, and the second part to global financial standards. So it relates to the presentation from Mr. Devaux. I will make 2 points for each if I have time, or otherwise on the second part only one. You will stop me, Concetta, if I'm going long. So as for the FBF judgment, my first point has to do with the topic of the relation of this judgment with other judgments of the Court of Justice, and in particular with the thread that Professor Annunziata already illustrated so well about the relation with the ESMA judgment and ultimately with the Meroni judgment. I must say here I'm on the academic side. I see here there is a kind of division from the academic side and the practitioner side, in the sense that I also feel that we are moving forward and beyond Meroni, and pretty much in the same sense that the ESMA judgment was moving. But the very evident difference here is that while in the ESMA judgment, the court was referring all the time to the Meroni doctrine, here this point is never ever mentioned. But it is also true what Inchi was saying before, that these are two different cases in the sense that here we are dealing with a rulemaking act, while in the ESMA case it was an executive act. Still, the point of the discretionary nature or not of the act is never taken into account. Also, I see a step forward from ESMA, in the sense that in ESMA, different conditions were taken into account, while here really the key point is the scope and depth of judicial review. And I see here that this judgment is in a way strengthening the powers of the my second point on the FBF judgment has to do specifically on judicial control on soft law. So it is true, as Professor Annunziata was saying, that this is a general attitude of the Court of Justice. It's not specifically innovative, but it is innovative in applying it to the soft law of the agencies. Here, I'm pushing this argument a little bit forward. In which sense? In the sense that I agree a lot with the Advocate General Bobeck view in his conclusions on this point, in the sense that this is the second best solution, and it is something that was coming out also from Madame Chamsor intervention before, in the sense that it's true that allowing for an indirect challenge is not entirely equal to having an action for annulment. Why? For several reasons. The first reason that was put forward by Advocate General is the fact that we have a mismatch in the sense of the fact that we have the privileged applicants who are in a disadvantaged position because they cannot challenge directly soft law. And from the second perspective, there is the principle of judicial effective review, in the sense that here we have a mismatch from what is allowed at the national level, in the sense that the case law of the Conseil d'État admits the action for excès de pouvoir against any soft act from national authorities, also for the reasons that were coming out from the intervention before mine, in the sense that not all soft law is equal. But here I'm a little more pessimistic than the intervention before mine, in the sense that the case law, the Court of Justice, appears to be very much settled on this point. This judgment is coming 3 years after the judgment in the case Belgium versus Commission, where there was the same Advocate General, Bobek, who was really trying to push forward an opening on using the action for annulment for soft law, and it was not admitted. So I don't see an opening on this point coming anytime soon. But still, I mean, it is the second best option, the one of having this type of judicial control. Now I'm moving to the global standards side of the debate, and I have one question for Mr. Deveau, which has to do with the perspectives of global financial standards. In the sense that for sure standard setting in the financial area is not at all a new phenomenon. As you recall, before the setting up of the Basel Committee dates back to 1974, the first standards, like the most well-known first capital accord dates back to 1988. Anne-Marie Slaughter, so prominent political scientist from Princeton, already at the beginning of the years 2000 was studying the Basel Committee and the IOSCO, saying they were the architrave of a new world order. But still, it is very much true that the whole standard setting process at the global level gained momentum and support, political support, after the global financial crisis of 2008. And in the last decade, really, there has been an implementation of an agenda that was set up between 2008 and 2012 by the Financial Stability Board in a dialogue with the G20. So I'm wondering if you see this path going on with the same type of timely action that we've witnessed in the last 10 years of this, if this process in a way slowed down a little, also given the general situation of international cooperation at the moment. I don't know if I have time for a last point, otherwise I will close it here.
2 minutes if you...
Okay,
just to handle this point in 2 minutes, yes. Okay.
Yes, no, but my very, very last point is about accountability of global financial standard setters, in the sense that Mr. Deveau referred to this point at the end of his presentation. Now, this is a concern that it's not only coming from academics, but also from institutions. There was a recommendations of the European Parliament some years ago that was asking for example, for EU bodies to commit to participation in global standard setting more than what they were actually doing up to that time. But this opens up the whole other bunch of questions. So who would be better equipped to participate? Whether would it be EBA, whether would it be the European Central Bank? And General Counsel Perassi recalled before that one crucial element of any accountability framework is judicial review, which is what we've been discussing today with regards with soft law at the EU level. Of course, we do not have that possibility at the global level, if not maybe in a very indirect way in acts that are implementing, European acts implementing global standards. So also on this point, I would be happy to have maybe Mr. Deveau point of view. Thank you.
Thank you very much. I guess that we are a bit run out of time because 2 hours haven't been passed, but I guess that I also guess that the audience that is still connected is reduced, but not too much. 60 people are still connected, so probably they would like to, will be pleased to have a short discussion. So if any of the speakers would like to pose some questions or to answer, for example, Diego, I see that you are keen to answer to Maurizia question, we will be very pleased to have a short discussion. And also, if there are questions from the participants on the chat, I will read the questions. Please, Diego.
Concetta, thank you so much for giving me the floor first, because I have to leave for another meeting. So I would be very pleased to try to answer the two questions raised by indeed Maurizia. So on your first question, clearly I can see probably a need to slow down now the path of regulatory reforms at the international level, because there is time for implementation, there is time for streamlining, there is time for making the overall architecture, let's say, more understood and made practical. And indeed, what you mentioned, the risk of geopolitical dimension, given what's going on in Ukraine and elsewhere, this polarization of the world between East and West may not facilitate the international process. So clearly, that's perhaps the first answer to your question. But of course, we will need to talk more about that. Now, with respect to accountability, the De La Rosière report a couple of years ago, and indeed the need to interact with policymakers in the EU or elsewhere, in the US as well. This is a very much welcome debate. Obviously, I understand that this is not totally excluded, because I know that, for instance, the secretary to the Basel Committee has been to the European Parliament. I think there are some interactions between the international standard setters and the policy makers. They went also to national parliaments, also in France or in the UK. So it's not that this dialogue doesn't exist, but obviously an accountability to national bodies would be contrary to the essence of the working of international standard setters, because they want precisely to have the freedom to try to reach a consensus at technical level, and then it will be up for each national authority to make sure that what they feel needs to be implemented will be consistent and duly reported and made available to their national authorities and national parliaments. But this issue is not specific to the EU. We had the same issue in the US, because under the Trump administration, there were a number of bills proposed by the Republicans that were suggesting that basically the US should not be part of this club of old boys discussing behind closed doors and basically committing the American people without accountability. So there were draft legislation that obliging the Fed and other US agencies to disclose basically their agenda and disclose the discussions and seek approval before reaching consensus within the international framework. But that was not put in place. And if made in place, this would have meant the end of the Basel process, because you cannot reach a consensus at the international level if you disclose the national positions. You need to have, sorry for my broken voice today, you need to have a kind of international dialogue and seek compromise, and you cannot do that if you basically you have a dialogue with 28 national parliaments and relevant bodies. So I think that is the drawback of the Basel process. And I stop here because I don't want to take the floor too long, but I will have to leave, unfortunately, because of my other meeting. Thank you very much for having invited me.
Thank you very much, Diego. It was very important for us, your presence here today, also because we think that the strength of soft law, or the soft law based on multilateralism, and we really think, and we would like that we are not seeing the dawn of multilateralism due to this, to the war, and to this, as you have already underlined, this East and West. Yes, I strongly believe that we should stick to this point. Multilateralism is very important. We should be all together in the future. We should really, it is important, notwithstanding this terrible war. Thank you very much for your presence, because it's important. Thank you.
Thank
Bye.
you very much. Bye-bye.
Donato, you have a question?
No, I have an answer. No. I would like to react to thought-provoking input from Madame Chamsor. She wondered, if I got it correctly, whether it should be possible to challenge a Q&A directly based on its effect vis-à-vis the bank raising the question and receiving the answer. Of course, well, it depends on the Q&A, on the kind of Q&A, and on the kind of question, but authority, sorry. But I'm wondering whether the simple act of disregarding the Q&A in itself would amount to a violation of law by the interested bank. My guess is that that would only be a clue of a possible negligence to be weighed against all the other circumstances of the case. And as a consequence, I am wondering whether a wannabe plaintiff would actually have an actual interest in the judicial claim. But of course, I am open to other inputs on this regard. Thank you.
Yeah, I mean, without taking up too much time, I think that the problem is that banks would not, as a practical matter, take that risk of having the negligence be held against them simply because they disagree with the Q&A. So as a practical matter, even if they disagree, they will comply. And while the case law is premised around Article 263, it's premised on the fact that if you have the possibility to not comply, the act is not binding. If you don't have that possibility, then I think the question should be posed.
Thank you very much. Thank you very much, Hameli. Also, your participation was really very important, because the point of view of market participants is crucial. Is crucial because we have to balance. We have in the past we were used to moral suasion from. We used this word, no, from authorities. Now we have soft law that is not binding as moral suasion was, but to a very limited extent, as you underlined, Amélie, is challengeable before a court, and but probably currently authorities are more transparent, are more accountable towards the markets. We try to find a way out. Thank you very much. Inci, the floor is yours.
Thank you. Yes, very quickly, I wanted to also make a comment on the Q&A point. From a legal perspective, I have full understanding of what Amélie just said. I understand all the points. I just want to also highlight why the Q&As are there, and it was not from the beginning foreseen in the ESA's regulation. We had the guidelines, which we are consulting on. We get lots of feedback. We have opinions now. We're consulting also on opinions. Now we have Q&As. We are not consulting on them even, right? Even to for your argument. But I think they're very important because we must not forget. I mean, also to let you know, Commission also had Q&As, very long history of Q&As on payment services, for example. Just to also let you know that the questions on level 1 are answered by the Commission. Questions on level 2 and 3 are answered by the ESAs. This was always like this from the beginning. Now, the question, I also dealt with Q&As, and the first ones I dealt with back in 2013 were so technical questions on grandfathering, own funds. I mean, it was such details of details. It was very technical. Also, still today, there are aspects of long formulas. There is one variable. Is it like this or like this? The bank has to apply it tomorrow. No, it has to apply it yesterday. And they don't know, like this or like this. If I do this, will the supervisor be happy? Because they are depending on their supervisor. They need to know an answer now and today in order to be able to act. That's why we don't only receive questions from competent authorities, but it's lots from banks who say, give us the answer. We need to know. We need to know 2 months ago. And we should also not forget this this importance of the answers that that help the market. But I fully understand the legal concern, to be honest. Yeah. Thank you.
Thank you, Inci. This is a good occasion also to open a discussion. This is the aim of this Centro di Ricerca or Research Center, and so we are happy of this. Filippo, you would like to have a last word, and I should thank you first because to discuss this topic was your idea. We have discussed 6 months ago about this, and so thank you very much for having helped me in organizing this also.
Thank you, Concetta. I must say I am really very happy about this seminar because it confirms my impression that this decision should not be taken lightly. It's like a kaleidoscope with a lot of refractions in all areas. But to sum it up, I would like to raise, just to touch four flashes. Flash 1, the problem of the legal basis of soft law still remains. What Inci was saying makes absolutely sense, but I invite you to make an exercise. Try and apply her comments in an environment where we have a clear legal basis and in an environment where we do not have a legal basis. If the two lines of reasonings are very different, in the second case, what we end up by risking, it's just a risk, is that we use concepts such as risk, management of risk, internal governance, blah, 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 as the eye of the needle through which the dromedary or the camel must pass. So there is a difference between having a clear legal basis and an unclear legal basis, as in the EBA product governance guidelines. The second point is Meroni. Okay, Meroni, the ghost or not the ghost. The fact is that after this decision, if you measure the temperature of how much discretionality the ESAs have, my personal opinion is that the temperature has gone up. Then we can discuss and say Meroni is still there, it's not there, but the ultimate result is that take the temperature of the discretionality, it has gone up. I think this is very clearly comes up also from Maurizio and also from Amelie's comments, and it's really difficult to forget about that. And this is the second green light. The third one, Amelie, thank you so much for taking Article 277 up. My impression is that it will be very rare to have an enforcement kind of decision, such a supervisory decision, which is directly based to soft law. In my experience, I see that soft law comes up indirectly as part of the decision, but then the decision will always be, at least from my experience, will generally be grounded on some kind of hard law, because otherwise it could be too easy to challenge. And then I think we should have another seminar on the new products of soft law. And it's not by chance that while the decision was being cooked in the kitchen of the Court of Justice, the ESA's regulations were amended by inserting new provisions that specifically tackle Q&As, opinions, and etc. I think it may be by chance, but I think that chance does not exist in this world, and that the ESA's regulations were fine-tuned and fixed a little bit, you know, sort of a way of, let's see what comes up also from that case, and so we prepare for the future. And then the future is now made of more granular provisions on soft law, which may even be a way to handle the problem of the Meroni. I think there is a lot of Meroni back thoughts in the new provisions of the ESAs in relation, for instance, to how Q&As are produced and so on. But thank you also for raising the fact that we now have very different kinds of soft law measures that should be considered separately.
Thank you very much, Filippo. I think that we can conclude here. Just one last word from me. When I was listening to your consideration, to the all participants' considerations, I have the impression at the end that after all we have said, soft law currently is part of the legal system of the rule of law. We can say this, and this is an important progress, I guess. In any case, we can debate about the effects, but now is part of the rule of law system. So in my opinion, it's a positive novelty in any case, even though we should fix a lot of things. Thank you very much to all the participants having accepted to stay with us today, and for the frank discussion, and for the food for thought, food for thought, the opposite. They gave us for future reflection on this. Sorry. Have a good weekend to everybody. The same webinar will be recorded, and you can see, if you would listen again, on the website of Centro Feroluzzi, Roma 3 University. In 1 week, it will be uploaded, the recording of the webinar. Have a good weekend. Bye. Thank you again.
Bye.